Good morning, ladies and gentlemen. My name's Alex Barker, and I'd like to welcome you to the 10th, welcome you to the European Parliament for the 10th International Right to Know Day, a day that aims to give everybody a better means to shine a light on the exercise of power. Our topic today is accountability and transparency at international development banks. Specifically, we are turning our attention to independent accountability mechanisms, which are at their best, offer people a right to recourse, a way to expose injustice, challenge decisions, resolve disputes, and promote good practice in development projects. We have a wealth of experience assembled here from civil society and every international financial institution you can imagine, with representative of development banks operating from Japan to Eastern Europe to the tip of South America. We will all want to hear more about the IAMs and what they represent, and apologies for slipping into acronyms already, but I think we'll hear a lot of those. But as well as wearing awareness, this event is intended as an opportunity to meet people, exchange ideas, get some complaints off your chest if you have any, share some of the best ideas in the field, and reflect on what has been done and what can be improved. And the theme throughout, of course, is the principles and accountability and transparency. Before moving on to people with far more interesting things to say than me, I should probably give a brief explanation of how the event came about. The IAMs have been busy this week in Luxembourg for the IAM network meeting, hosted by the European Investment Bank. It happened to coincide with Right to Know Day, which the European Ombudsman is now turning into a regular annual event, and you can probably see the sense of bringing the two gatherings together today. So the IAM world has travelled up from Luxembourg to join us and make this event possible. It seems a good moment to pass on to two distinguished gentlemen beside me. First of all, the European Ombudsman Nikiforos Diamandouros and Feliciano Alcarpe, head of the European Investment Bank's complaints mechanism. First of all, Ombudsman.
Thank you. Thank you very much, and good morning, ladies and gentlemen. I want to thank Mr. Barker for agreeing to moderate our latest International Right to Know Day, and I also want to warmly thank all the representatives of the independent accountability mechanisms, otherwise known as IAMs, that you'll be hearing about, for coming to Brussels late yesterday after finishing a rather tiring 3.5 days of meetings in the EIB, because Mr. Alcarpe, the head of the complaints mechanism of the EIB, is also one of those who believes that one should work rather than take it easy, and therefore worked us very hard before he got us here. But we're very happy to be here, and I want to welcome him, and I want to welcome you and all the representatives of civil society who also have come. So my grateful thanks to you for being here, and of course to the members of the panel. As Mr. Barker said, this is the latest 10th seminar on the International Right to Know Day, and it is the third time that the European Ombudsman organizes an event on this date. And I'm genuinely happy that we've managed to turn this into a regular highlight on our agenda. International Right to Know Day constitutes an opportunity to put the spotlight on transparency and accountability around the globe. This year, we have closely cooperated with the complaints mechanism of the European Investment Bank to organize the event. And once again, I would like formally to very much thank Mr. Alcarpe, the head of the complaints mechanism, and his team for their help in getting this high-level and very international panel together. As Mr. Barker has explained, today's event is not only about raising awareness of the independent accountability mechanisms in international financial institutions, also referred to as IFIs in case this kind of pops up. It is also about discussing what these mechanisms have achieved so far and what can still be improved. Above all, it is about what these mechanisms can contribute to the important principles of transparency and accountability, principles which go to the heart of what the European Ombudsman does at the EU level and which are also increasingly recognized worldwide as essential aspects of good governance. The basic principle of transparency, which EU law reflects, is that public access to documents and to the information they contain should be the norm, and secrecy should be the exception. Every year, I receive around between 2,500 and 3,000 complaints from citizens, businesses, NGOs, civil society organizations, and associations. The most common cause of complaint is lack of transparency in the EU administration. But I also deal with other complaints, for example, about the execution of EU programs and projects or the infringement of the treaties. Last year, transparency-related cases represented 25% of the inquiries closed. They included complaints regarding refusal to give access to documents or information, the Commission's expert groups, the Commission and Parliament's joint transparency register, and lack of transparency in the EU institutions' decision-making procedures. You will note, of course, that despite all this complaint that I receive against the Parliament continues to be a very good hostess, and hosting institution allows us to use their magnificent settings for our meetings. To be sure, there are indeed cases where secrecy is justified and in which, therefore, I find in favour of the institution. Overall, however, I believe that we have not yet succeeded in convincing all civil servants and institutions that transparency is the norm and secrecy the exception. Achieving that cultural change and thus creating an open and accountable EU administration is key to building citizens' trust in the European Union. You might still wonder what the European Ombudsman has to do with international financial institutions such as development banks. Well, the Ombudsman also deals with complaints against the European Investment Bank concerning the projects it finances. That is the reason for my institution's presence in the IAM network. We cooperate very closely with the EIB based on a Memorandum of Understanding signed in 2008. The agreement committed the bank to adopt measures that are intended to ensure its effective engagement with complainants and other stakeholders and to enhance the transparency of its activities. Furthermore, it commits the Ombudsman to dealing with all complaints concerning EIB-funded projects in the same way, whether or not the complaint is an EU citizen or resident. This is very important because many EIB-financed projects take place outside the European Union. It is crucial to note that complainants first have to address the EIB's complaint mechanism before they then can turn to the Ombudsman. Mr. Alcapa will explain the activities of this mechanism to you in a moment. Only 4 cases dealt with by the EIB's complaints mechanism have subsequently escalated to the Ombudsman. 2 of these concern the length of time taken to finalize the complaints mechanism's assessment. The other 2 raise substantive issues. The EIB settled one of the cases concerning delay by sending the assessment to the complainant. My inquiries into the other 3 cases are still ongoing. The European Ombudsman is not only a guardian of transparency. He is also keen to promote a regular and open dialogue between the EU institutions and civil society. In the current economic and political crisis, dialogue becomes even more important, if not indispensable. I hope that through today's event, we can contribute to promoting another form of dialogue which goes beyond the EU institutions. The compliance mechanisms of international development banks have done a lot in past years to enhance the transparency and accountability of many important projects in Europe and around the globe. I very much look forward to hearing their experiences from which we at the EU level will also be able to learn. I'm delighted to have so many high-level representatives of civil society organizations on the panel and in the audience today. They will not only contribute their valuable insights into best practices, but will also highlight areas where improvements can still be achieved, and there's always room for improvement. I hope that we can arrange more of these dialogue seminars in the future in order to exchange experiences, search for best practices, and of course, provide networking opportunities. I thank you for your attention, and I look forward to a fruitful debate.
Thank you very much. If I could turn to Mr. Al-Karpi.
Thank you, Mr. Chairman. Good morning, ladies and gentlemen. Mr. Diamandouros, thank you very much for your kind words and for all the support that the European Ombudsman institution and the European Ombudsman, they are giving to the EIB complaints mechanism, which is crucial to ensure our effectiveness. It's a pleasure for me to be here with you for this seminar on the International Right to Know Day. And it has been an honor to organize, together with the European Ombudsman, a series of events around the 9th annual meeting of the IFI's Independent Accountability Mechanisms, known as IAMs. We started already last Tuesday at the University of Luxembourg with a symposium on IAMs, accountability and human rights, which included a session on the Aarhus Convention. And what better way of closing our annual meeting than engaging with civil society in discussing transparency and accountability. The IAMS group is a network of members and staff of international financial institutions, accountability mechanisms, who seek to identify and foster means for cooperation within their respective mandates, contributing to regular exchange of ideas and best practices, and assist with institutional capacity building in accountability as components of corporate governance. Let me briefly explain what is the EIB complaints mechanism, known as EIBCM. EIBCM, in my understanding, is an instrument of EIB Group horizontal accountability, also called citizen-driven accountability. It aims at providing the public with procedures enabling the alternative and preemptive resolution of disputes between the public and the EIB Group. In this context, one of the major objectives of the IBCM is to ensure the right to be heard and the right to complain of any IB stakeholder, thus giving voice to their concerns. Indeed, any member of the public has access to a two-tier procedure, as already introduced by Mr. Diamandouros. First, the IBCM, with an operational independent service of the bank, independent from all operational departments, which will investigate and try to find a solution to the case and may advise the IB management on remedial and or corrective action where necessary. Should the IBCM fail to find a solution or to provide an appropriate response, it's possible to refer the complaint to a full independent European Ombudsman. And to this effect, the IB and the European Ombudsman have signed a Memorandum of Understanding back to 2008, which was the basis for the establishment of the current complaints mechanism policy at the IB, which was approved already in February 2010. The question, who may complain? Complaint, in our case, can be launched by individuals, organizations, corporate, civil society, affected or feeling affected by the IB activities. Complainants do not need to prove that they are directly affected by the IB decision, omission, or action, and they are not required to identify the rules, procedures, standards that could have been breached. The subject of complaint can be any action, decision, or omission by the IB group. Can be about access to information, can be about environmental and social impacts of projects, can be about procurement procedures, customer relations, activities on the financial markets. What is most important for the discussions that we are having for the last 3 days and also today, it's the complaints may relate to any aspect of the planning, implementation or impact of the IB projects, including but not limited to process followed in the preparation of a project, the adequacy of measures for mitigation of social and environmental impacts of the project, arrangements for involvement of affected communities, minorities and vulnerable groups, and the manner in which the project is implemented. the operational effectiveness of operational independency and effectiveness of the IB complaints mechanism is ensured by our final responsibility regarding the decision on the admissibility of a complaint, the decision on the type of mediation, investigation or activity that will engage to deal with the complaint, and the final responsibility for the conclusion report that we provide at the end of the process. Our conclusion reports are public unless the complaints request otherwise. The IB complaints mechanism has different functions. I'll start with the two major ones. One is the investigation of compliance to determine if the IB is compliance and applicable, the IB compliance with applicable rules, regulations, and other provisions, policies, standards, and the adequacy of those provisions. We have another function that we call it mediation or conflict resolution. If agreed by the parties, we can facilitate different forms of collaborative resolution between complainants, banks management, project promoters, national authorities. And complainants may ask specifically for one or the other. But the decision is up to the complaints mechanism, taking into account the request, the opportunities, and the need. Additionally, the IBCM performs two other functions, which are the monitoring and follow-up of all the recommendations that we brought to the attention of the IB management when handling complaints. So we follow up on the implementation of such recommendations, and an advisory role to EIB governance bodies. Within the scope of its responsibilities, the IBCM provides advice on broader and systemic issues related to policy, standards and procedures on the basis of lessons learned during the handling of the complaints. This was just intended to be a brief description of what we do. You will find for more information in the detailed documentation that is available to you. Now I wish you very fruitful discussions for the rest of the day, which in my mind will certainly contribute to push the transparency and accountability agenda forward. Thank you for your attention.
Thank you very much. Very kind of you to talk us through your organisation. Now, if we could move on to the first panel, which is explaining the transparency and accountability in action and the role of the IAMs. We have a distinguished panel. To my left here is Alf Järv, who is chair of the inspection panel of the World Bank, an anthropologist by training. He's spent close to 3 decades in the development field, including on international study teams, as a coordinator of aid projects, and as a director of the Christian Michelsen Institute. On the far left is Rustian Lubis, who of the Asian Development Bank's Compliance Review Mechanism, a body which investigates alleged non-compliance by the ABD. He has 3 decades of experience in environmental management, working with the government, university and private firms in Indonesia, and at the World Bank as a senior executive. To my right here is Peter Hlobin of the CE Bankwatch Network, which monitors international financial institutions operating in Central and Eastern Europe. He's worked for and with NGOs since the early 1990s, specialising on energy issues and climate change. Far right is Helen Derbyshire. Hello, Helen. Who is executive.
European trade.
Yes, yeah. Who's executive director of Access Info Europe, a human rights group based in Madrid. She's promoted the right to information and greater transparency from Europe to Latin America and Africa. She's also founder of the Freedom of Information Advocates Network and inaugurated International Right to Know Day. So, now, we were slightly overrunning, so I'm going to be ruthless in enforcing the 7 minutes for each introductory speech, and then hopefully we'll be able to move on to some Q&A and questions. So, Alf, if you could start there.
Thank you so much, and thank you for this opportunity. I mean, it is the Rights to Know Day, and I think we should admit that we as mechanisms, the World Bank's inspection panel included, we are not well known. So this is an opportunity to at least ensure that we become better known also among NGOs and decision makers here in Brussels. So let me go quickly through a presentation of who we are and some of the challenges we are currently facing in our operations and what we sort of very briefly have been doing over the years. Very shortly about the history. This is a kind of exciting history in the advocacy around the World Bank. We go back to the 1980s when the World Bank was severely criticized for supporting a number of projects that were labeled development disasters. The World Bank at the same time also developed its own environmental and social safeguard policies. We also had in 1992 the famous Earth Summit in Rio that also set a focus on issues of people's participation in development and social and environmental issues more broadly. These various pressures led to a decision in 1993 by the board of the bank to establish an inspection panel, as it was labeled, and I'll tell you a few more words about that. Our role is to respond to complaints by people who believe that they are suffering or also may suffer in the future some form of harm caused by a World Bank finance project. What we can do as a panel is to investigate whether the World Bank has followed its own policies or procedures in the planning or even its own appraisal of the project, but also in its supervision of the implementation of the project, and how the bank's own application of its policies or lack thereof links to the issue of harm that has been raised. And our mandate covers the IBRD and IDA, or sort of the public financing part of the World Bank. There is another mechanism for the private sector financing under the World Bank Group, the IFC and MIGA. We are a three-member panel, and two of us are here today. We come from different member countries of the bank, and we are appointed for 5-year non-renewable terms. We are supported by a secretariat, permanent secretariat in Washington, and also importantly, when we carry out investigations, we make use of international expert consultants. A few important characteristics of the panel and the process that we undertake. We are independent in the sense that we report directly to the executive directors, the board of the World Bank. Hence, we are independent from management and bank staff, but we are also independent from civil society and requesters. We have our own budget and we recruit our own staff. And we also carry out independent visits to affected people and to project areas. It's an important feature is that we are an impartial body. We should carry out fact-finding in an objective and impartial manner. And also, in view of the emphasis on transparency, every document related to the panel process is made public. There are certain provisions in terms of timing of public disclosure, but all documents eventually are public. I will not go into details about our process, but it's important to emphasize that this is an interactive process. It is a process where the panel plays a crucial role, but also the World Bank management, as well as the board, in order to produce the kind of outcomes in terms of possible redress or even institutional learning that is desired from this mechanism. What we have done over the years since operations started in 1994, we have dealt with 80 complaints altogether. This is not a big number given the total amount of bank-financed projects over these years. Maybe one reason to that is that we have not been well known over these years. The complaints have come in from all regions where the bank is active, And of those 80 complaints, 40% went to a final investigation of the bank's compliance with its policies. The remaining 60 were not investigated for different reasons. In some instances, the panel found that the matter had found a resolution, so an investigation was not recommended. In some cases also the board did not approve an investigation, because that is also part of the process. There are some bank policies that most often feature in these complaints, and the four on the top are the policy related to project supervision. Complaints often come in when projects are under implementation. It's the bank's environmental assessment policy, a policy on involuntary resettlement, and a policy dealing with indigenous peoples' rights. There are two broad sort of outcomes that we can define in relation to this process. One is the access to recourse and the potential of redress for affected people. And through investigations or through these panel processes, we have seen results in terms of better compensation to people, enhanced environmental mitigation measures in projects, and generally an improvement in information to the affected population and also their involvement in implementation or decision-making. There is also another important indirect feature. It is that the process itself provides people an opportunity for voice, for strengthening the role vis-à-vis decision makers and general empowerment, and may also jumpstart problem solving on the ground. In terms of more broader institutional effects, the mere existence of the panel provides an incentive on staff in the bank to apply safeguards and be more diligent in the way they carry out their assessment on social and environmental issues. Investigation also yield lessons on policy application and compliance with policies in important areas, like environmental assessment, various forms of impacts on natural resources and land management, on aspects of how to ensure that there is meaningful consultation in a project, and also how to determine, for instance, indigenous people's rights in a particular project. It's also a factor that access to recourse and access to a complaint mechanism enables risk-taking for a development institution. The fact that people have an opportunity to raise a flag and say that we have concerns, I think is also constructive for achieving better development outcomes generally, and to prevent that risks are transferred to the most vulnerable. Finally, we do have challenges. All of us, we have challenges in the institutional environment in which we are operating. And here are just a short list of sort of current trends. There is currently a change in lending instruments in the World Bank, in most IFIs. For instance, there is a move towards the concept of results-based or more retroactive financing. It is will become more difficult in the future to establish a causal relationship between bank dollars or money and actually things happening on the ground, compared to what we saw in the past when the bank was more directly involved in concrete projects. There is a move towards stronger country ownership, application of countries' own safeguard policies and environmental legislation, and relying less on, in that sense, on the bank's own prescriptions. And also policies are now under review in the World Bank. The safeguard policies, as I'm referring to, are under review and are likely to come out in a less prescriptive format, more principle-based. There is also an ongoing discourse about the bank's competitiveness in the financial market and whether having too heavy safeguards is reducing the bank's competitiveness. And there is also a discussion about risk and whether too much oversight makes the staff in the bank risk adverse. And we are also sort of caught up in this debate trying to defend the rationale for why we are needed and why people need this mechanism. Thank you very much. And if you want more information, this is our website, and we also have our annual report outside for those who are interested. Thank you.
Thank you very much. And if I could move to Rustian to tell us about the Asian World.
Thank you and good morning, ladies and gentlemen. My name is Rustian Lubis. I'm the chairman of the Compliance Review Panel of ADB, and I would like to be very quickly to introduce my colleagues from Manila, from ADB. Ando Ritros is a member of the panel, and Mr. Jeff Crook is the Associate Secretary of the Office of the Panel, and Mr. Preber Nielsen, he is the head of the Office of Special Project Facilitator, which is one leg of the panel. I will go quickly on the roles and definition, which I will not discuss it too long, but basically with this, the unit or the mechanism is to assess the people who are affected by the ADB project, who can voice and resolve their problems and request a review of compliance with the ADB operational policy and procedures. We in ADB think that the panels, especially the CRP, is the last resort mechanism where the complainants have to exhaust their effort to bring the complaints through the grievance mechanism at the project level, and then comes into the management, bank management, and finally to the accountability mechanism, which is the CRP and the OSPF. We have two functions, as I mentioned. One is the problem solving through mediation with Mr. Nielsen. He is the head of the OSPF. And then the CRP, which I chaired this panel. This is a three-member panel. One is permanent, 5 years, non-renewable, and two part-time members, also 5 years. We have so many complaints, and it's not every complaint become a case, because one day we can have complaints on a consultancy, and even one time we found the complaint on credit card fraud, which is not really our job to deal with this one. So we have an exclusion when dealing with all the complaints. Number one, that we do not deal with issues related to ethics, misconduct, procurement, housekeeping of the bank. And then also we do not deal with project beyond 2 years after completion of the project. Also about the inadequacy of the bank policy and policies that relates to government action and regulation. So we do not deal with this kind of complaint. The last one, which is a bit difficult to it's a bit need a lot of thought, is trying to find whether the complaint is not frivolous, not malicious, not trivial, and an effort just to gain competitive advantage of the complainants to the bank, to ADB. What are the expected values of accountability mechanism? One is that the bank especially has to complain to the policy from the outset. I'll give you the examples in one of a project in Sri Lanka. And we also expect that the project will have a better design and implementation. The other values of the AM is that fair compensation to losers, because in every development project we know there are winners and losers, but if you study the Pareto optimals, that always compensation has to be given to the loser in the project. And the last one is the better stakeholder participation in the project, from the planning, from the outset into the monitoring, which is again because the government roles in the monitoring is also very strong. I'll give you a very good example on this cases that we just finished last year. The Southern Transport Development Project in Sri Lanka, this is a 128 kilometers highway from southern part of Sri Lanka. The bank financed the highways and also road safety equipment or in that road. The total project cost is for $148,000 million. ADB loan is 180 million, and co-financing by Japan and the Sri Lankan government. This project request come in December 2004. We completed the final report in 2005, so it's only one year. I think Mr. Richard Bissell somewhere here that he also deal with the project. One of the luxuries that ADB has, I think, compared to other institutions, I guess that we have 5-year monitoring process. We started in 2006 and just completed in March 2011. And you can see this more or less the lesson learned from that project. Number one, there is no doubt there is more awareness of ADB safeguard policies in the project implementation. I think also the World Bank share that experience, I guess. Number two is that this project also promotes institutional strengthening within the government agencies and consultants. For example, with this project, now that the Sri Lankan has what they call the RDA, the Road Development Authority, was basically stemmed out from this project, and other bottom level or ground level grievance mechanism was set up by the consultant. Number three is more attention to land use planning and urban development. And many countries think that road project is just road project, you building the asphalt and all this equipment. But in the case of Sri Lanka, the government realized that it's not just about road project. This is also about land use planning and urban development all along and within the project. They realized it through a very probably grudgingly they realized that it's very important in the future project in Sri Lanka. And I think the last one is to improve the grievance redress mechanism within the project. The project has 5 years monitoring, and every year we come back to talk with the people, and gradually you can see that yes, indeed the redress mechanism was improved in the ground level. The last one, of course, this is no wonder that the government also think that the project, because of it's not just because of CRP involvement, but the project will also increase in the cost, delay of the engineering, and somehow over focus on social issues, because issues like engineering, environment, and other issues was kind of overshadowed by the issues of social and resettlement policy. It could be expected in a huge resettlement project like that. What are the challenges of the accountability mechanism? I think this is all shared, I guess, by the other institutions. Number one, that the panel, especially the panel, has to be independent, to be credible, and to be impartial to when we do investigation. Secondly, is the quality of facilitation and compliance review processes. It's a long process, and it's quite tiring, and it creates some kind of pressure not only to the panel but also to the bank and the government. Then, how to maintain the support from ADB, from the affected people, the other stakeholders, public, especially country ownership. And the last one is the greater transparencies and information disclosure and participation from civil society, like you're here. The other issues that we discussed yesterday is the human rights issue, the global impact, and other. I will not go into this very clearly, but I think the system is in place. Civil society should keep knocking at the door of the MDBs. But then again, we have to realize that the accountability mechanism is only an internal tool of the institutional accountability. We cannot deal with external or too many global issues. Recommendations are not binding, not adjudicative, and not judicial type remedy. The last one is the country's sovereignty that can limit our roles. Thank you very much.
Thank you very much. And sorry for having to cut you short there as well. But
Sorry?
Sorry for having to cut you short.
That's
But,
okay.
if I could turn to the NGO side now and to Ped to speak to. Thank you.
Thank you very much for the word and for the invitation to this event. I'm really honored to speaking with so many people who are dealing with the accountability mechanisms. And I start with the apology that I start to play a bit with the titles of the session. The one before I start to speak, I would like to make it very clear that most of the NGOs are actually great supporters of the accountability mechanism. And my own organization, Bankwatch Network, we were pushing the establishment of the mechanism in the EBRD and EIB. And so if I say few critical words, it's not because I believe the mechanisms are bad, but I'm saying those because we believe that they should be better, they should work more effectively. Excuse me. I also believe that over the time we can see that the mechanisms are making some of the important steps in order to ensuring a greater accountability and access to the information in particular. And here I would like to underline one thing which may be slip of attention of many people. EIB compliance mechanism start to pushing the staff to releasing the environmental conditionalities in the loan agreements. I do believe this is the first institution which is doing so, and I do believe that this is a very important step, because that allows actually citizens to see what is written in the contracts, in the legally binding documents. It's not just the statements of the bank. When I started preparing for this, I thought that we often are lost in the Article 17, paragraph C, 3. And so I would like to go back to what is accountability for, to take it a bit broader perspective. When I look to the Aarhus Convention, it's looking for a process which is timely, fair, equitable, and free or inexpensive. And I pick up, two examples to look into this. But actually, and that was said also before the Aarhus Convention was adopted by the NGOs on the plenary. What is really accountability for is that we want to be heard. This is very simple. We want to have a place when common citizens can raise their concerns. They can speak with people who will listen to them. And I think that's the very important and essential part of the accountability mechanisms and should not be forgotten. Let me pick up one example from the EBRD. This was, community affected by the coal mining, and their complaint was rejected for the following reasons. Due to proximity of the affected houses to the mining field B, which is not part of the scope of the EBRD project, your complaint cannot be registered and reviewed by the project compliance mechanism. If you look to the public map, which is standing in the company, which is accessible to the public, they even identify that the field B and C are actually B and C on the map. If you look to the whole, there are no borders. So I was really wondering how without a proper investigation of this issue, the compliance mechanism could be so sure. On the top of it, if we look to the history of the EBRD engagement with the Serbian energy company, they are investing in that same region in the different fields since 2001. And in the first loan, in 2001 for the EPS, which is the energy service company in Serbia, supposed to promote a access to the information and public participation in the projects from 2001. I think this is raising important question. Would the citizens of the region feel after the case be so easily dismissed by the letter, a trust that the institution is taking care of them, is thinking about them? And for me, that's one of the big questions. I happened to be in the region one day after they received this letter, and the frustration of in the room of that group of citizens obviously was very high. But also we went through the regions and we met there a man who was thrown away from Srebrenica during the conflict in the Balkans. He lost 15 hectares of his forest, and he resettled to that region, and his son-in-law helped to buy him a house with the 1.4 hectares, if I recall it correctly. And now this same man was kicked off of his property by the energy company of Serbia on the field which was definitely financed by the EBRD. He complained to the company, and obviously they told him, get off. You get a compensation according the ratings, and that's all. With his compensation, he is able to buy only 0.35 of the land. So he is clear loser. This man is not going to complain to anyone else, because he's frustrated. His neighbors will tell him, don't go to EBRD. It's a waste of time. It's quite clear. Yeah? And what I believe it's actually worse on this case is that it's the question whether we can actually recommend using mechanisms like this. And I think it's the part of the issue which is linked with all of this is the institutional setups where the organizations like development banks are working. And I think the bankers living in one of the great myths. By the fact that the bank is lending to the company or the country, they would bring higher international standards. But those standards will be not brought unless they are properly monitored internally in the bank and unless they are implemented on the ground. So the problem is not whether the compliance mechanisms are effective. The problem is whether the institution staff are actually ready to promote their own tools, like their policies, like their access to the information regulations, etc., etc. I think the accountability mechanisms should be used only for the extreme cases. But I think the issue is how to change the culture of the institutions. Already before, Mr. Diamandouros mentioned the issue with the EIB and the length of the compliance mechanisms. One of the examples, and I need to be quite brief, was that investigation on the Bujagali Dam project took, if I'm not mistaken, over the 19 months. And this is the project which was investigated also by the other institutions. So there is already kind of great amount of the information which was built around. But I think it's part of the issue is that throughout this investigation, the EIB continued to support the project and disperse tranches of the loans. I don't think this was actually giving the great sense of the local people that they actually have a chance to influence something substantial on the ground, because the dams were built in the meantime. So now let me go to the few recommendations or conclusions. First one is that complainants, institutions cannot substitute for the safeguards and the transparency policy and the practices. It needs to be their issue for the bank staff. It's not up to the citizens to permanently begging, please give us these informations. This information should be available on the website. You know, this information should be available to the public, easily accessible. The second thing, which I believe there need to be sufficient resources, including the staff and the funding for all of the compliance mechanisms. Some of the delays are clearly linked with the lack of, staff within the compliance mechanisms. Currently, I think it's EBRD mechanism is investigating 4 cases. They have only 3 experts in the panels, and obviously that must causing difficulties. So I think that's need to be supported. I also believe that we should, as the public, be far more sensitive to the attacks on the independencies of those compliance mechanisms, which we do see. This year, EIB compliance mechanism, internal procedures were adopted, which actually asking the report be firstly disclosed to the management before it's disclosed to the public. It's maybe a small step, but I do see that it's directly attacking the independence of the mechanism, because if the management is the first one who has the right to speak and comment on that, it gives the management the privileges over the citizens, which I do not believe it's a good issue. I talk about the responding in a timely manner when corrective actions are still possible. People really asking for the dialogue. They want to be heard. They would like to see the people to whom they can speak, be in contact, because their grievance is actual. This is not theoretical process. They have a problem now. They would like to see that someone is taking care of this issue and looking to that with a fair eyes. And the last thing is it's something that over the time I believe that what is needed is in each of the compliance mechanisms, you need to have your own personal visions, what you want to improve in the institutions for the benefit of people which are out there. I saw a number of people who make major achievements in the institutions through focusing on particular issues and pushing institutions to making further steps. And I would like to encourage you to keep this work.
Thank you very much for a very thought-provoking presentation, and hopefully we'll be able to come back to some of the issues raised in that in the discussion to come. But before then, we can turn to Helen.
Thank you very much. Good morning, everybody, and happy Right to Know Day. Happy 10th Right to Know Day. Thank you very much. It's great to be an honour and privilege to be back here with the Ombudsman celebrating this day. But just for all of you to realise, this isn't just one event. There are many, many events going on around the world today. I've been following activity on the Twitter feed, tweets from South Africa, from Nepal. So what I'm going to say is a couple of words about the context in which we're having this discussion, and then some specific comments on the IFIs, their transparency and the transparency of the accountability mechanisms, and hopefully to get a debate going. So you can imagine a sort of number like 10 causes people to stop and pause for thought for a moment. And there's been a lot of discussion in the last few days about what has been achieved in the first 10 years of International Right to Know Day. Perhaps the first achievement, and it's very important, is the recognition of this right as a right by various international human rights tribunals, including the European Court of Human Rights and the UN Human Rights Committee. And of course, here in Brussels, the treaties of the European Union post-Lisbon recognise a fundamental right of access to European Union documents. That's a very significant paradigm shift that's taken place in the last 10 years. I was looking at some of the documents that we created 10 years ago when the FOIAnet and Right to Know Day was founded. And it's the kind of thing we aspired to, but I'm not sure if we really dared to hope that we would achieve it in even just 10 years. I was in the OSCE in Warsaw 2 days ago, and I heard words very similar to yours, Nikiforos, in the opening, talking about the presumption of openness and the need and the idea that transparency is a fundamental right with only very limited exceptions in certain circumstances. That's a significant achievement. There are questions here which I'll come back to in a moment about if this is a right, how does it apply to intergovernmental organisations as well as at the state level or in Brussels' case at the sort of super state level. Clearly, getting something secured as a right in theory and in law, we have 93 access to information laws around the world. About 2/3 of the world's population, at least, is living in countries where, in theory, at least, not always in practice, but in theory, they have a right of access to government bodies. I'm not one of them. I'm not one of them. I live in Spain, and Spain has not yet recognised the right of access to information. We just lost a case before the Supreme Court in Spain this summer. We wanted to find out what Spain was doing to implement the UN Convention Against Corruption. We asked a request 5 years ago. We just got the Supreme Court ruling. They said that we didn't have a right to ask that question, and we've been ordered to pay €3,000 in costs for having taken the case. Spain doesn't have an access to information law yet either, although there is one before the Parliament. So even in the European, that's probably the most serious, out of the EU member states, that's the most serious situation in terms of recognising this right to ask. It is pretty serious, but it shows that we have challenges. My colleague Pam's got some documents, nice pretty coloured documents. This is the last year on Right to Know Day we launched Ask the EU, and this is the analysis of the results from the first year of the website where people can file requests with the European Union. The figures may be slightly different from what the EU itself publishes, but perhaps not too different. We have 37% of requests getting full information and another 28% getting incomplete information. We've got a fairly large amount of administrative silence, 12%, although I would say that that's not bad if you compare it with the international level. There are some issues in the way that requests are handled in practice, but that's something I won't go into more detail now. But it's important always to have the data on implementation in order to understand where we are with this right in practice. Because after all, at the end of the day, this is a right not just in and of itself, but this is a right that is there to permit citizen participation in decision-making and to ensure accountability. I think I heard the words citizen-driven accountability, which is what it should be about. So when it comes to the... and then in terms of the international financial institutions, that paradigm shift that I talked about, a shift towards a presumption of openness, has definitely occurred within many of the IFIs. Last week I was in Helsinki listening to a representative of the World Bank. His official title was Open Data Evangelist, which I don't think are words I would have understood 10 years ago, or maybe even now. So the Open Data Evangelist from the World Bank encouraging civil society to rank countries on their transparency. It was fantastic. I do think that we've seen in the last decade that paradigm shift within the international institutions. The World Bank itself has a policy which puts the emphasis on a presumption that information will be disclosed with limited exceptions. That's very important, as is the transparency around the independent accountability mechanisms that we're talking today. And it was very welcome to hear the confirmation that in at least I think 2 out of 3 cases I heard specifically that all documents are made public, some perhaps sooner than later, but that the documents are made public. The question I have then really is that transparency sufficient? And I think, Peter, you touched upon it. If we can't get the information necessary to be able to take the complaints to the accountability mechanisms, that's the point at which the citizen is frustrated. It's about the public knowing, having that right to know in terms of knowing about the mechanisms, but it's also having the documents, the evidence base sometimes, to be able to take the case. And with the World Bank, one of the concerns is the question of harm. Whether, and I think this is what you were picking up on as well, whether you can actually demonstrate the harm and Alf Morten, you talked about the difficulty now that we're going to see going forward in identifying a causal relationship between the World Bank dollars and a particular development project. So if it is hard to see that causal relationship, how are we going to begin to demonstrate harm? If the money is flowing through governmental bodies or through other channels before it actually gets to the project on the ground, it's going to be very difficult to identify where to take the complaint. And I think that in the increasingly complex global structure that we have, that is a huge problem. We see it in the European context as well. Who is taking decisions about the financial crisis? How do I, as a citizen, follow what is going on? What kind of information can I get and from where in order to be able to perhaps raise my concerns? At what point am I going to take a complaint to the Ombudsman about a particular decision that's affecting me? Does it come from Brussels? Does it come from my national government? We see that the same problems with the flow of things like structural funds, where I'm working with civil society organisations which just get bounced back between their national bodies and the EU in terms of who's taking the decision on how this money is going to be spent. I think that's a huge problem for us going forward. We have something called the International Aid Transparency Initiative, which is trying to promote much greater transparency around development projects, international aid and so forth. And that would include all the work done by the development banks. Until we have that really much more comprehensive, proactive transparency, there will always be a limit to the way in which the complaints mechanisms can ensure, and this is what we want to achieve at the end of the day, that the money is being spent in the best, especially when there's less money around, as there seems to be these days, that the money is being spent in the best possible way, most efficiency, with least corruption. And that's also, just to raise one other concern before I finish, the question of we don't deal with ethics. Well, isn't that what it's all about? You know, good administrative practice, good ethics. I think that harm is, I understand the difficulty in trying to identify really concrete harm, but if we're looking for real good governance, then we need to focus on the ethical dimension as well, and clearly cases of corruption and so forth. So really, to conclude, we have achieved significant levels of transparency, and that is very important and something on the 10th Annual International Right to Know Day that we can congratulate ourselves on, pause for thought for a moment and celebrate. But at the same time, we have huge challenges, and those challenges become more complex in an ever more complex world. But that's precisely why this discussion and debate is incredibly important. So thank you again for inviting us here to have it.
Thank you very much, Helen. And we can now open it up to the floor. Before then, I've just had a gentle reminder to remember my history. And it's appropriate that we're in the European Parliament because it was hearings in Congress and here that helped create the pressure to establish these kind of mechanisms in the first place. And it does seem appropriate that we're discussing this here. If I could take the first question.
Thank you very much. My name is Jana Mittermeier. I'm representing Transparency International. And of course, first of all, we also welcome the existence of the accountability mechanisms. But my question today goes to Mr. Jerv from the World Bank, because you mentioned in your presentation that since '94, the World Bank had dealt with 80 cases, and 40 of them were investigated. That means that actually in total it's 32 cases investigated in 18 years. Did I understand that correctly? And you also mentioned that the World Bank could perhaps do more to promote the mechanism in order to have more citizens and also from individuals from the public and the private sector to understand the mechanism and to really use it. So is there any progress? And at the end of this, I would also extend this question to Mr. Alcarf and Mr. Lubis. How is it in your mechanism and in your banks? I mean, how many cases do you have, and how many of them were investigated, and how many of them are corruption cases? Thank you very much.
Okay, let me just briefly answer your question. Yes, it's correct. Your mathematics are correct. We have had only 80 cases, and that probably translates into about 32 investigated cases. Why this low number? I think one factor is definitely that the World Bank management has not been proactive in making this mechanism known. And there is a need for pressure on the World Bank on that account. There is a lot more that can be done, not only by the bank itself, but also the bank in cooperation with the borrowers. I think there should be a principle that the availability of such international IAMs should be informed to people who are potentially or are living in a potentially project influenced area, together with maybe also other options of recourse, because there can be domestic options, there can also be project-specific mechanisms for recourse. And I think there, as we are moving forward, there is a need for greater attention to that level. Also because, of course, IFIs tend to advocate more the use of country systems, so you also, of course, need to strengthen national recourse mechanisms. So promoting the IAMs broadly, I think, is a very important question. I may also, if I may, quickly respond to Helen's question about transparency within the IAMs itself. And I think there are two important issues, at least from our point of view. And that one is that demonstration of harm on the part of requesters should not be an admissibility criterion. I mean, this is a debate, and the resolution for the inspection panel somehow is not entirely clear on this one. It can be interpreted as being a restrictive requirement, or it can, and we have tried, the panel also before me have tried to not apply this as a criterion. That is up to the panel to investigate whether there is a link, not for the requester to demonstrate in order to access the mechanism that there is a link. Another aspect of transparency in our process is the question of whether it has to be a provision that the board needs to see reports before the public can see them. I mean, this is currently a basic principle. Investigations reports are made public only after a board discussion. But one could question why not that the reports are made public before a board discussion, so that the board discussion takes place when also public has been aware and can have used and may have commented on the investigation. So I think this is an important discussion going forward. Thank you.
Thank you. Let me answer this. The last issue that we also share with Alf is the issues of harm. Harm is quite difficult and elusive sometimes in case by case. For example, in the case of resettlement, we can see that people losing their houses, they're losing their livelihood. It's easy to find there is harm, which can also quantified become into monetary harm. But in many cases, and for example, on the issue of air pollution, water pollution, direct material harm is not easily recognized. And that's where the judgment of the panel is needed in that sense, which was backed up by the scientific, not evidence yet, but scientific, some kind of scientific understanding and what would be the harm. And again, I agree with Alf that in many cases this is not the complainants who has to say there is a harm there, but then the panel is, after some kind of investigation on the eligibility, the panel will decide whether there is harm or no harm in this case, and whether the complaint become a case or no cases. It's not always one-on-one relation between, the other issue is not always one-on-one relation between harm and non-compliance. That could be many cases there's non-compliant, but it's no direct material harms, but also there's harm, but it's not really related to the bank non-compliance of the policy. That's my and I also share with this Alf on whether harm might not be another criteria for the complainants when they bring the cases to the IFIs. On the how many cases that comes to ADB, again, CRP, especially CRP, is the last resort in the process. So cases could come a complaint could come into the country level and mediated by OSPF, is now chaired by Mr. Nielsen, and takes time because in the old mechanism we use a sequential process. You have to follow the country first and then the OSPF. Now CRP will take it as the last resort. But now with the changes of the control mechanism, it could be, for NGO, it could be more accessible to the compliance panels. We have 6 or 7 cases so far since maybe 8 years ago, and 1, 2, 3, 4, 5, 6 is investigated now, and 1 is still ongoing process of the eligibility criteria. Thank you.
Thank you. If I may start to respond to the question about more statistics. Well, first of all, we do not investigate complaints on corruption and fraud. Yeah. If we find suspicion of corruption and fraud, we pass it to our colleagues from fraud investigation. In terms of number of complaints, last year, the statistics for 2011, we have 56 complaints, of which 48 have been accepted and investigated. But those complaints include a broad range of subjects, talking about project-related complaints, impacts of environmental and social impacts. We have 18 complaints last year. Since 2007, in total, we received around 70 complaints on project impacts, of which roughly 90% have been investigated. So that's for the statistics part. Coming back to the discussion between proving harm and compliance, as we work in a completely different context, the EU legal framework, we work on the basis of good administration, the right of the citizens to good administration, and good administration, as it has been defined also by European Ombudsman jurisprudence and in our own policy, includes compliance, but goes far beyond compliance, includes respect of human rights, includes satisfying legitimate expectations of stakeholders and that type of thing. So it's not so crucial to prove the link with harm, between the project and with harm. Just a brief comment on the progress made in transparency, which I fully acknowledge. So the policies are there, the right to know is there, but we still have some progress to make in terms of proactive disclosure by the institutions. That's one thing. And to come back to the presentation where BIB is mentioned, I fully agree that there is a risk in general for accountability mechanisms in getting enough resources to perform their functions adequately. This is an important risk. And the other is the efforts from management to downgrade the policies as they have been approved. And I think civil society has a role to play in putting pressure to maintain the high standards that those mechanisms were created for. Thank you.
I just want to make a couple of brief comments to help move the discussion forward, if I may. but I also want to take the opportunity to acknowledge the presence in our midst of Mr. Cashman, member of the European Parliament and a very strong friend of transparency and of the Ombudsman's efforts. Thank you for being here. Three very quick things that tie to what has been said already. Okay? Both Helen and Peter talked about the issue of whether reports should be seen by management before they got the public. When consulted in terms of the EIB, the Ombudsman recommended against this practice. I just want to be on record that this is what our position was. Secondly, I want to say generally from my meetings last week in Luxembourg with the IAM, but also with an academic seminar at the beginning of the week organized with the EIB, there was a very strong sense coming through all the discussions, particularly the academic seminar, which I think was reflected in your comments. Ultimately, in very many quarters where decisions are being made, citizens are regarded as a nuisance. And that is, of course, what we talk about when we say we need a culture shift. Okay. You don't lose by not looking at citizens as a nuisance. You simply need to deal with matters in a different way, which also brings me to the letter that you, Peter, read about the case in Serbia. From my perspective as a European Ombudsman, that particular fragment that you read is, in fact, poor administration. You don't answer citizens this way. You provide them with much broader and more comprehensive rationale for why a decision has been taken, rejecting, rather than saying, sorry, you're not eligible, have a good time, in your life. So I think the rationale, there is a right to good administration, which means that you're under obligation to provide reasons for your decisions, rather than saying, this is my decision, all good health to you. And my final comment is to say that there is an international movement that's been launched with about 50 or 60 countries called Open Government Partnership. And that is an important further step forward. I'm aware that virtually all the member states of the European Union have actually signed on to that partnership, but it is important to record it for your information. Thank you very much.
I think at this point it might be worth giving a right to reply to the EBRD on that point. I think it's Mrs. Begoyan at this.
Good morning, everyone. My name is Anush Begoyan, and I am the Project Complaint Mechanism Officer of the EBRD. I'm the person who wrote that letter that was cited over there. I would like to thank Mr. Ombudsman for giving us this opportunity. I think it's very important to have this opportunity to sit down with the civil society representatives and talk about these very important issues. And while we all, I think, recognize that proliferation and strengthening of our mechanism actually brings more accountability into our institutions and into our projects. And I would like also to mention that there is another huge aspect of what we do, I believe, is educating our clients, which is extremely important. When we engage with clients, I believe we are bringing in some examples of what is a good administration, what should have been done, how to respond to a complaint, how to engage with these communities. And that brings certain corporate culture and corporate ethics into these companies as well. And that's, I believe, extremely important. And I want to believe that that's a legacy which we are probably leaving behind when we are leaving the process already. However, having said that, I'm afraid there are huge challenges as well, and there are certain limitations to what we can do and what we cannot do. In ideal world, it would be perfect if we could go into any project that EBRD is involved in and solve all the problems that are there. We cannot do that because these development projects are quite often very complex. They're co-funded. EBRD is involved, as it is in the case of Kolubara, for example, only in very minor parts of the project, like installment of a new coal management system, so it's an environmental improvement project. The mind was there, for example, in this case, from 1950s, and all environmental and social impacts are there for decades and decades before the bank was even established. And it's very challenging, and there is a temptation to go in and try to solve problem of all the people that are impacted. However, I'm afraid our mandate goes only as far as our money do, because that is the leverage that our accountability mechanism can use in solving these problems. I think it's quite unfortunate that Peter didn't mention that that was already the third letter that was wrote to the community, and it was wrote after 2 months of very detailed investigation on what could be done and what couldn't be done. Unfortunately, Peter also forgot to mention that there is a complaint that is registered by EBRD on Kolubara mine that comes from another community which is actually very close to what we are doing, and we are involved in resolving this issue. But it's important to recognize these limitations. And finally, just a quick comment on the issue of the harm, because I think that's extremely relevant for us as well. Most of the complaints that we had was on, were requests for the compliance review. Our mechanism has two functions: it's problem-solving initiative and it's a compliance review. And we have this requirement for showing the harm for both functions. However, we took a slightly different approach when we were assessing them. For example, when it comes to problem-solving initiative, we actually want to see a harm, because there should be a problem that we can solve. We have to see what the problem is, what the conflict is. When it comes to compliance review, which is basically a question about the integrity of EBRD's decision-making processes, we think the harm should be implied. If there is an allegation that there was non-compliance with rules, then that's a harm in itself. So that's the approach that our mechanism is taking. There's just a brief comment on that. And as I said, I mean, because there is a registered complaint, I cannot go into more details and discuss it now, but I'll be happy to provide maybe Peter with more details on that later. Thank you.
Thank you very much. I think we've only got about 15 minutes left, so I don't want too much of a to and fro on that individual case, but it's very good to get some context as well. But any other questions? The lady.
My name is Keith Kozloff. I'm the Director of Accountability for the U.S. Private Investment Corporation, the U.S. government's development finance institution. And I just wanted to, maybe picking up on this last exchange, focus on the recommendation that Peter made about responding in a timely manner when corrective actions are still possible. For me and my institution, part of the challenge is that the project development cycle involving public consultation and design and environmental impact assessment and so on may not mesh very well with the project financing cycle. And I recently finished a case in which public consultations and disclosure were really conducted about 2 years before my agency became involved in financing. So there was no way to go back in time and fix what were the deficiencies in the public consultation at this point. So it poses a problem in terms of sequencing. And I guess that I just wanted to comment that some of our agencies, besides problem solving and compliance review, also have advisory services that we can offer. So it seems that there's an opportunity to build capacity to avoid the need for corrective actions in the first place by having both the financing teams in our agencies as well as the clients who develop the projects, you know, in a better position to engage with communities. And I think there's a role that accountability mechanisms, at least those that provide these advisory services, can play in that regard.
Yes. Just firstly to answer, obviously I took only the quote from the letter. There was more justification to be all, in all fairness to the to Anush. I think I was actually trying to make a broader point that overusing opportunities of a complaint like this, look to the project which is funded which is done by the company, where the EBRD actually have the engagement from 2001 over the 11 years. So number of mechanisms, in theory, should be established within the company already before. And I think that's actually easy case, I would say. I think the more complicated things are to come. The EIB, EBRD, World Bank, all of them have the trend to start financing more and more through the financial intermediaries. I mean, through the private banks usually, private equity companies. There you actually have no right to see the information which projects are financed. So how you know that the EIB policies could be applied if you even do not see the list of the projects which are funded, by the institution which is providing. I think that starts to be a very, very serious and complex issue. And then obviously all of the accountability mechanisms are, even if they are good, you actually cannot use them because you do not know that they would apply. I think that's the issue. Yes, there are always, challenging issues with the length of the investigation and things like that. But also, I do underline one of the things which, I found with the meeting of the communities who are affected of the projects. They very much also striving to have a face-to-face contact, to have the people with whom they can speak. And I think that's something that I wanted to also underline. This issue, what we want to be heard, is not a correspondence of the letter. I think this I would not put it very lightly. The need for the direct communications in between the mechanisms and the communities itself. Thank you.
We can try and fit another question. The lady in the press car. A couple more. Yeah.
Good morning. Regina Schneider, European Environmental Bureau. We are a federation of citizens' organizations working for the environment, and transparency, good governance is one of our issues as well. Thank you for all the presentations. We heard a lot about cases, investigation of cases, but so far I'm missing the information of the follow-up. The outcome are recommendations, and as the word says, it's a recommendation, so no enforceability. Can you please tell us how you take care of the follow-up, make sure that the recommendations are respected? How do you inform the concerned citizens about the outcome of this? Then I've heard from several speakers that they were talking about mitigation, compensation method, etc. How do you monitor afterwards that this is really respected, and how do you inform the public? Thank you.
Alf?
Maybe I could start. You are pointing at a weakness in the World Bank's accountability mechanism. We explicitly have not been provided with a mandate to independently monitor the follow-up or the implementation of recommendations. We, as a mechanism, also do not have a mandate to specifically recommend, but there is an expectation that an investigation will lead to actions proposed by management and then subsequently endorsed by the board. So there will be an action plan of sorts as an outcome of an investigation, and it is the management responsibility in the bank to report on the implementation of those actions. In cases, management committed itself to one or several monitoring reports, and those reports are being made public. But we do not have a mandate to independently go out and sort of verify or check. But the reports are at least made public. So there is a possibility for, let's say, other stakeholders, NGOs and others, to try to be vigilant whether this is actually being implemented properly.
Okay, I think ADB is having a luxury of given a chance to monitor the recommendation. But by the way, before that, so the CRB, the panel gave the recommendation to the board, which then agree or disagree on the recommendation. the board will ask the management to follow up on the recommendation, with, of course, in collaboration with the government in that case. So, and then the panel has the mandate also to monitor this how this recommendation are implemented. And in the case of STDB, for example, the case that I mentioned it to you, we have 5 years of recommendation, but up to 5 years. Maybe you don't have to do it in 5 years. You can see that some of the recommendations are really followed by the management, and in collaboration with the government, they build, for example, the capacity building within the government, for example, on the road development authorities, and other issues that are also implemented by the government, the owner of the project. So we monitor that one. And of course, there was a debate whether recommendations should go beyond the CRP mandate. For example, should we go into too much detail on the recommendation? There was always dialogue between management and the panel when we discuss the recommendation. I think, if I'm not mistaken, Jeff, is the recommendation made public, right, on our website, or is that internal between management and CRP?
Sorry, my name is Jeff Crooks from the ADB compliance mechanism. So are you referring to the recommendations or to the...
Monitoring. Is the monitoring made public, or is it only for management and CRP to know?
Well, the monitoring reports currently are internal within the bank. They're not made public, and I think that's probably an omission.
Yes, on the question of the follow-up, we make recommendations that are related to the project, and we make recommendations on the systemic issues that we have found to improve the policies and standards. Later, we have an internal follow-up, and it's not public. On the project, in principle, it's public. I say in principle because our website is under creation, so there is some information that is not complete information available yet. Now, the type of follow-up that we do can vary depending on the type of recommendation that we have made, but our degree of involvement can be to go there with an full audit mission and provide an audit report, which we have done in a few cases, and can go up to us performing a full audit and a full assessment again to be sure that the situation has been corrected. I just wanted to come back with something that I heard about projects and financial institutions financing only a small bit of a project, because it has been a trend in all our financial institutions to try, if there is a problem where problems are anticipated, let's finance just that particular component of the project where problems are unlikely to occur. So we are on the safe side. Our approach, what we have done up to now, it has been difficult to enforce, but we have taken the approach. We look into the project as a whole. So even if you are financing, we have a case where the EIB was financing 10% of a project, which was about environment mitigation equipment for the environment, so very good for the environment. But we reviewed, we investigated the whole project. And it happened also in Bujagali. We have investigated a transmission line that the EIB was not financing at all. So we are taking the approach, the bank should ensure that on a given project, even if it only finds a small part, you need to ensure the application of its policies to the whole project. Thank you.
Helen wanted to...
Thanks, Alex. Just very briefly on Regina's question, because I think it's a very important question. Pretty much any transparency mechanism, system, is meaningless, useless, if there aren't complementary participation and accountability mechanisms. And accountability means knowing what happened afterwards, for being able to follow the full chain of the impact of any decision. And the Ombudsman mentioned the Open Government Partnership, which is something that people should know about, people in this room should know about. It's a very interesting initiative. It's new. It's just celebrating its first year. There's a European regional meeting taking place in, very nicely, Dubrovnik next week. Today, and the three pillars of this, it's a multi-stakeholder initiative. between government, business and civil society on how do we advance open government. It's a forum for brainstorming, for governments to make action plans. It has some failings. It's very much more carrot than stick-like, I would say, but that can be good as well. Interestingly, in the European Union, out of the European Union countries, I've just done a quick count, in fact there are 17 of the 27 who've signed up so far. Finland was the latest to join, and some big countries, France, Germany, Poland, for example, also Belgium, Austria, Ireland, are not members of the OGP yet. And apparently France and Germany have not shown much interest in it. So that's just to note. I think the question in Brussels, perhaps, is how does the European Union, which is a supranational state rather than a state, engage with this open government partnership process? But it is something, I think, from the perspective of thinking about International Right to Know Day and the challenges for the next 10 years going ahead, one of the challenges is definitely to link more tightly and it's very well, this debate perfectly illustrates it, to link transparency to mechanisms for accountability and participation, ultimately to the good of the public and the ordinary citizen. Thank you.
Just a very brief comment in response to Helen. It's interesting to see how information flows and how broken lines are communicated. My information came directly from the Assistant Secretary of State of the United States last year, saying that 26 of the 27 member states of the European Union had in fact signed the initiative to be launched in September last year. No. Okay. And in fact, the information was that what struck me was that the EU was not a signatory. And the issue for that, of course, was that prior to Lisbon, EU did not have a legal personality, and therefore could not sign. But now we're in Lisbon, and I took it upon myself to inform the President of the European Council, Mr. Van Rompuy, and the Commission has taken it over from then on. What they've done, I don't know, because it's not the Ombudsman's business to, in fact, monitor that particular issue. But at least so you'll know why we're, in fact, giving you different information. Obviously, we're having different sources of information.
Right on time. I'm afraid no, we have no more questions, but we'll be able to come back to a lot of the same issues after a well-deserved coffee break. So our second panel will start at 11:30. Oh, and before, sorry, I was asked to ensure that everyone from an IAM puts up their hand, so while you're mingling, whoever wants to talk to you can find you. So if all IAMs, there we go. Fantastic, there is. So you can be collared during the coffee break, but thank you very much. Thanks.